At the A4ID Climate Change Group session on the 3rd of April 2012, our speakers, Raj Bavishi from Simmons Simmons and Nick Flynn from Weil, Gottschall and Mange, considered key developments arising from the UN Climate Change Conference in Durban in November 2011, with a focus on the Durban Platform for Enhanced Action and the Green Climate Fund. In this first part, Raj Bavishi, projects lawyer at Simmons Simmons LLP, considers the legal nature of the decisions arising out of the Durban Platform.
The title of the presentation is Hopes and Challenges of the Post-Durban Regime. What I'm going to try and draw out are some of the positives that have come out after Durban and some of the challenges that remain in actually reaching some sort of global deal. I'll talk about two different things. First is sort of the broader Durban package, what was adopted in Durban. And then secondly, it's not exactly related in the context of the United Nations Framework Convention negotiations, but it will have a huge impact if it goes ahead, and that's a potential request for an advisory opinion from the International Court of Justice, which is potentially going to come for a vote before the UN General Assembly later this year, and I'll come back to that and some of the challenges that raises. Broadly speaking, the Durban package, they adopted something like 36 different decisions in Durban. The high-level political ones are the four that you see on the screen. One related to the Kyoto Protocol, one related to this thing called long-term cooperative action, which is essentially a stream of work that's been going on under the Convention in negotiating groups to determine what to do essentially for the period between 2009 and 2020. And then there's the decision on the Durban Platform for Enhanced Action. I expect I will keep referring to that as the ADP, which is the ad hoc working group for the Durban Platform for Enhanced Action. So forgive me for speaking partly in acronyms. And then the fourth one is the Green Climate Fund, which Nick will come back to. I'm not going to go through all these slides in detail. I think they're all going to be available later on online. I'm just going to pick out a few key elements from each one and then focus in particular on the decision establishing the ADP. In relation to the Kyoto Protocol, many of you will know the first commitment period expires later this year, at the end of this year, and in Durban they agreed that the second one will start from the 1st of January, except that they didn't really, because they didn't adopt the amendments necessary to actually allow parliaments to go forward and ratify that amendment so that it does actually enter into force within the relevant time frame. The work of that group is going to continue and will, we hope, finish in Qatar. I mentioned earlier the other decision in relation to the long-term cooperative action group, that's the AWGLCA. It was launched in 2007, coinciding to an extent with the fourth assessment report of the IPCC, which essentially told us that we need to do much more than we're doing. And so they launched this new negotiation to enable full, effective and sustained implementation of the Convention. At that point it was 2007, now up to and beyond 2012. We're already at 2012. And they were tasked with reaching an agreed outcome, not defined by that decision, by the Copenhagen Conference, which was one of the reasons why it was so built up in the media. Everyone thought that a whole new global regime was going to come together in Copenhagen, all the leaders were going to turn up, sign a wonderful agreement and everything would be good. Obviously that didn't transpire. We had a series of decisions in Cancun, and then in Durban in December of last year they decided actually for final that the agreed outcome wouldn't be a legally binding instrument, it would be a series of COP decisions. COP decisions being decisions taken by sort of the ultimate body that implements the convention. It's essentially the council of the treaty, comprised of all the member states. And the agreed outcome will be the decisions adopted in Cancun 2 years ago, Durban last year, and Qatar this year. It will come to an end, that working group, at the end of this year, and is intended to, the outcome of that is intended to cover the period up to at least 2020, though a number of the institutions, such as the Green Climate Fund, the Adaptation Committee, and various other institutions that have been recently established, are likely to continue thereafter. I really want to focus on the Durban Platform, the ADP, which was established in Durban was one of the key highlights of the conference. The press were very excited by it because they decided to launch a process to develop a protocol, another legal instrument, or an agreed outcome with legal force to be adopted by 2015 and to be as soon as possible, but no later than 2015, and to be implemented from 2020. The decision itself has various elements, and there are a number of implications which flow from sort of these 5 different elements. There are 6 up on the screen in front of you. I'm going to focus mainly on legal form and under the convention, and I'll come back to under the convention in a moment. Just quickly, in terms of the severance from the ad hoc working group on long-term cooperative action, which is going to terminate this year, that was established by the Bali Action Plan in 2007, coinciding with the 4th IPCC assessment report. And the outcome of that was this agreed outcome, which they finally decided was going to be COP decisions, and then they launched this new process for the ADP. What the ADP is doing was originally seen as being part of what the AWG-LCA was meant to do, but for whatever reason didn't get there. One of the key implications of moving it from the existing working group into a new negotiating group is that it severs the link, it breaks the link between the mandate for the AWG-LCA, which very heavily featured the principle of common but differentiated responsibilities, one of the key foundation building blocks of the climate regime, which the wording of which does not appear in the ADP decision, the decision establishing the ADP. And so the extent of the linkage between the Bali Action Plan, the BAP, and the ADP is really a matter of political will and whether the parties can agree to carry over some of those elements, which ultimately means there's no guarantee that the principle of common but differentiated responsibilities and respective capabilities will apply in the same way in the post-2020 regime to the way it has in the past. Now, on the issue of legal form, which was one of the sort of hottest topics in Durban and took the longest amount of time to agree, they finally came up with this protocol, another legal instrument, or agreed outcome with legal force. And there's been a lot of debate, both at the time and since, as to what do any of these mean. Well, protocol is fairly straightforward. It's generally accepted to be legally binding under international law, such as the Kyoto Protocol. It's provided for itself by the Convention, the United Nations Framework Convention, in Article 17. Another legal instrument, there has been some debate over whether it's legally binding. I think the general view is actually it kind of has to be, because the Convention itself talks about legal instruments and goes on to talk about the adoption of protocols, which is already covered, and the adoption of amendments to the Convention, amendments to annexes to the Convention, or the adoption of new annexes. And in my opinion, in any case, that's what another legal instrument covers. Now, reasonable people can disagree over that, and I've had a very long disagreement with one of the UK legal negotiators, and we don't agree on this specific point. But broadly speaking, we agree that whatever comes out of the ADP must be legally binding. Now, agreed outcome with legal force is slightly trickier. It's not a recognised term in negotiations, it's not a recognised term in international treaties or other multilateral environmental fora. Has no precedence. It's similar to the wording agreed outcome in the Bali Action Plan, but it has that extra with legal force. Now, what does that mean? Does it mean legal force internationally, domestically? I think it kind of has to mean internationally, because you can't get states at the international level to dictate domestic laws, though obviously what they do at the international level influences what action national parliaments take. So if it means internationally legal force, well, is that quite the same as legally binding? The words legally binding did not make an appearance anywhere in any of the draft versions, iterations of the decision that was ultimately adopted. And that was very intentional, because legally binding gives lots of people lots of certainty as to what the effect of the agreement's going to be. Using the term with legal force raises a number of questions. Jacob Worksman, who's sort of he's a lawyer at the World Resources Institute and has been involved in the process since the very beginning, suggests that the two terms, with legal force and legally binding, are slightly different. but ultimately that they both have the effect under international law of creating obligations. But it suggests that it's slightly softer than what legally binding conventionally means, and we sort of take that to mean treaties, protocols, agreements which essentially have to be ratified. So, I mean, we've been giving some thought as to what agreed outcome with legal force could encompass. Now, there's a series of different ideas out there. I'm going to talk about three. The first is unilateral declarations. These have been accepted by the ICJ as being as binding under international law, and they can be made by an official of a state in the name of the state undertaking that state will do or not do a particular thing. But there's a problem with unilateral declarations because they're made by the states themselves. They get to decide what they're going to declare unilaterally. And it basically means they can pick and choose what obligations they want to follow. They can decide their own level of ambition. So even if the science tells us developed countries need to cut emissions by 40% by 2020, each country could say, well, to be fair, I can only do 15%. My parliament won't let me, my industry won't let me, so I'm going to unilaterally declare that my target's going to be 15%. Well, that's not particularly helpful. And it's quite difficult to ensure a global response where all the different countries have differing sets of obligations and not the same obligations. So it makes it very hard for compliance purposes. So I don't think that's a very good idea, though it's one of the ones on the table, clearly. Another one is sort of international agreements which aren't subject to domestic ratification, or things that fall within the power of the executive. In the US, you hear a lot about self-implementing agreements or treaties which the President can sign on behalf of the United States, which don't require ratification from the Senate. One example that's always pointed to is the implementing agreement in respect of United Nations Convention on the Law of the Sea, which the US was actually never a party to, though accept the majority of its provisions as representing customary international law. And the implementing agreement, 1995 implementing agreement that the United States signed, they signed just through the power of the President. It was never submitted to the Senate. And it's argued that this could potentially be one of those other agreed outcomes with legal force. The problem with it is that in order for that to work, the President really needs to have the authority already to do any of that stuff. The national laws have to already provide the government with the space to increase their mitigation ambition or increase their finance pledges that they pledge to developing countries. And it's highly unlikely that any country in the world at the moment has the existing domestic legal framework to allow their states, their state representatives at the negotiations to agree to such an agreement. And then the final question is over COP decisions themselves. Now, I mean, generally they're not legally binding unless the treaty itself provides that the conference of the parties of the treaty has the authority to make legally binding decisions. Examples, I guess, you can find in things like the Whaling Convention or CITES, the Convention for International Trade in Endangered Species, allow, or the Montreal Protocol on substances which deplete the ozone layer. The governing body of those treaties or protocols allows that governing body to adopt legally binding amendments to the treaty. Now, with the UNFCCC, it's not the case. The COP doesn't have that power. And so any COP decision adopted as saying, which says it's the agreed outcome with legal force, is not going to be legally binding. Various countries do insist that for them it's legally binding. India is one of the sort of key examples, but a number of others too. But I think that's going to be a difficult argument for them to sustain in the longer term, and it may well just be a negotiating tactic for now. I think we'll have to wait and see as the discussions on the actual legal form continue. Under the Convention, the term under the Convention is important because in the ADP decision itself, it says that they will negotiate this protocol, another legal instrument, agreed outcome with legal force, to be under the Convention and applicable to all parties. what's interesting about the ADP decision is that it doesn't reference the term common but differentiated responsibilities anywhere. And given that that's a cornerstone of the regime, that's slightly surprising until you sort of delve a little bit deeper and realise actually the political circumstance in Durban made the inclusion of the term inclusion of CBDR in the text impossible. Developed countries, a number of developed countries would have insisted on any reference to CBDR being sort of tempered, if you will, by the use of the term by reference to current economic realities, by some sort of dynamic interpretation of the principle, essentially trying to apply the principle in a different way to get the bigger developing countries to take on more responsibility, which is why it doesn't appear in the decision. But because it says it's under the convention, it really, from a legal perspective, it implicitly invokes the principles of the convention, one of which is common but differentiated responsibilities. And it all boils down to the fact that all this sort of back and forth over CBDR just disguises the fact that there's a big disagreement as to how CBDR should be applied in the future of the regime. And that plays through in the use of the words applicable to all. Though it doesn't mean equal obligations for everyone, it just means that the treaty binds every party. And it's possible to have a treaty which binds all people, so is applicable to all, but differentiates commitments. The Kyoto Protocol does it, the Montreal Protocol does it. But there are a number of, taken together with the fact that we have under the convention and no reference to CBDR, suggests that and the fact that we've severed the link from the Bali Action Plan, in which CBDR featured very prominently, suggests we're sort of moving away from the existing and the historic application of CBDR. Just quickly, I mean, those issues, the severance from the Bali Action Plan, the final legal form, which remains undecided, and the lack of reference to CBDR, are going to take a lot of the focus of the negotiators. But actually, one of the things that we need to make sure is that both the substance of the actual agreement doesn't get neglected, and also that the character of the actual agreement is not neglected. The legal character involves the legal form, which is one of the headline issues, but also the nature of the commitments. Are they mandatory or discretionary? Are they specific and prescriptive, or are they very sort of ambiguous and vague? And fourthly, is there a compliance mechanism with effective enforcement mechanisms? In the fight over the three headline political issues, it's possible that some of these other issues will get neglected, and it's one of those things that we need to do as much as we can to avoid that falling away. Otherwise we will be led to either an agreement which has no substance or very poor substance, or if it does have very good substance, it will have no sort of real teeth, because it won't be able to be you won't be able to hold countries to it to comply with them. The International Court of Justice has, as well as taking contentious disputes between states, it has an advisory jurisdiction where, pursuant to the Charter and the ICJ statute, various UN organs and agencies can request an advisory opinion from the ICJ. The UN General Assembly and the Security Council have general competence, and so they can ask questions on any legal matter. Two of the examples up on the screen are the Kosovo advisory opinion, which came out last year or the year before, in which the court was asked to look at the legality of the unilateral declaration of independence given by Kosovo, and similarly another one from the General Assembly on the legal consequences of the construction of the wall in Palestine, the wall advisory opinion. Other UN organs and agencies can request the ICJ for an advisory opinion on matters which are specific to their field of competence. When the World Health Organization submitted a request on the legality of the use of nuclear weapons, it was rejected by the court because it was held that it didn't fall within the environmental remit, the health remit of the WHO. Instead, the General Assembly, after that, submitted a further request, which was then accepted because it had come from the General Assembly. In September 2011, the President of Palau went to the General Assembly and announced that his state and various other island states, including the Marshall Islands, were going to seek an ICJ advisory opinion on the responsibility of developed countries for climate change. If it goes, discussions have been, sort of diplomatic discussions have been ongoing, and if it does proceed, it's likely to become before the General Assembly in this autumn. And given the preponderance of, or the majority of developing states, developing countries in the General Assembly, it's likely to pass. It only requires a majority. Given the timeframes of the ICJ and the time it takes them to make decisions, if the resolution passes the General Assembly, we're not going to get a decision before mid-2015, and that time is really important. I'll come back to that very briefly in a moment. Just to note finally that Palau is taking very, very good legal advice at the moment on the specific question that they might pose to the court. There's been experience, especially with the Kosovo advisory opinion, that if your question is bad, the opinion will be bad. The advisory opinion on Kosovo was kind of a nonsensical request because it was asking a question which really didn't have an international law implication, and so the advisory, the ICJ came back and said, well, it seems to be fine, it doesn't violate any international law. Whether it has any practical effect is a completely different matter. The initiative, the request for an advisory opinion raises a number of quite difficult and complex issues. The first is, the ICJ in recent cases, pulp mills being the most prominent in 2010, hasn't shown any interest in environmental issues. It's quite a conservative bench. There's 15 judges, all of whom are sort of quite happy to muddle along doing either use of force cases or maritime and land boundary disputes. Human rights have sort of fallen away in the Georgia-Russia case where they declined jurisdiction, and there are no particular judges on the court at the moment that sort of champion environmental issues. Back in the 97, in the Gabčíkova-Nađamaros case, there was a judge on the court who, in his separate opinion to the judgment, did a huge amount for the development of international environmental law. And in the nuclear test cases back in the 70s, the president of the court essentially stopped the court giving a decision in that case because he knew that an adverse decision was going to be more dangerous than sort of avoiding the question altogether, which is what they did in the case. Which comes back to the question that it gets asked of the court. An adverse judgment could prove hugely problematic for anyone that wants to see the UN framework Convention on Climate Change negotiations succeed and reach a global deal. Because if the court comes back and says, no, there's no international obligation on developed states it's likely they're going to drag their feet. I'd like to speak about ITLOS, but I think I'm running out of time. But it's a really interesting question as to whether or not it would be a more appropriate forum. It's the International Tribunal for the Law of the Sea, which is created under the Convention on the Law of the Sea, and has shown more willingness to engage with environmental issues. But in respect of an advisory opinion, there's a big question over whether it has jurisdiction. The statute for the court itself doesn't provide the court, as a whole court, the jurisdiction to hear advisory opinions, but the judges, when adopting their rules for the court, have appropriated for themselves this advisory jurisdiction. So there's a big question over the legitimacy of the court's advisory opinion jurisdiction, and any decision that flows from that will necessarily be tainted. Finally, there is a link between the advisory opinion and the ADP outcome, whatever it may be in 2015 or earlier. It's an issue of timing. Progress in the negotiations have historically always come about when there's been a milestone. So the first assessment report begat the negotiations for the Framework Convention. The second one did the same for the Kyoto Protocol. The third one helped with the sort of final ratification and the Marrakesh Accords of the Kyoto Protocol. And the fourth one led to the Bali Action Plan. There's real hope that the fifth IPCC report, which comes out in 2014, it will start coming out in bits from next year, but the full report comes out in 2014, and there's a huge hope that actually that will focus the minds of negotiators and states so that they give the world an ambitious outcome. Coupled with that, there's the review of the outcome of the AWG LCA, which is due to be completed in 2015, which could feed in if it demands more action, if it says our mitigation commitments are not sufficient, could increase pressure on states to have a more ambitious outcome out of the ADP. And if you weigh that against what might happen in 2015 with the advisory opinion, if it comes back negative, that's going to be a drag on any momentum that the IPCC can gain, the LCA review will gain, and potentially even Rio from later this year, are all sort of milestones for building momentum for an ambitious deal in 2015, if not earlier. And an advisory opinion could set that back quite some way. And so I think the key here is for those states involved in requesting the decision, the advisory opinion in the first place, have to think very carefully about whether or not it will do more harm than good if they go ahead with it.